Thank you. Hello, my name is John Russell. I'm a commercial barrister at Quadrant Chambers, and I specialise in shipping, energy, and international trade. My QBiT talk is, what is piercing the corporate veil? One answer is that it is a truly terrible metaphor that has only sought to hinder the rational development of English law. Now, that is absolutely true, but it would make for a short talk, even by QBiT standards. So we have to delve a little bit deeper. Before we address the question of what is piercing the corporate veil, we need to consider the anterior question of what is the corporate veil itself. Well, the corporate veil is a way of describing a fundamental principle of English law, known as the rule in Salomon and Salomon, that a company has a separate legal identity from its shareholders. Lord Templeman, no less, described this as being the unyielding rock on which English company law is founded. And very important consequences flow from that principle. In particular, the rights and liabilities of a company are separate and distinct from the rights and liabilities of its shareholders and directors. And the property owned by a company is the property of the company, not the property of the shareholders. It's a universal principle, and it has been thought that it is legitimate for business owners to keep a separate legal identity from their companies. Their personal assets are not on the line if the business fails. And similarly, a parent company's assets will not be on the line if a subsidiary business fails. This promotes business and economic growth. It's clear that just using a corporate structure to avoid personal liability is not a reason for piercing the corporate veil. Thus, attempts to get round the principle by piercing or lifting the corporate veil have usually been deprecated by the courts. But there is a tension between that approach and the view that the corporate veil should not protect fraudsters or others guilty of serious impropriety. As Lord Denning said, famously, fraud unravels everything, and that includes the corporate veil and the rule in Salomon. Judges have been prepared to pierce the veil to defeat fraud, and thus, on the face of it, abrogating an otherwise sacrosanct principle. However, for a long time, it was hard to discern any clear principles in the authorities as to when or why the veil could or should be lifted or pierced. The case law was as much a mess as an unravelled veil itself. Now, however, considerable clarity, at least of analysis, if not of outcome, has been achieved by a rather magisterial judgment of Lord Sumption in a 2013 Supreme Court case called Prest and Petrodel. It was a family case, and the principal issue was whether properties held in the company's names, companies owned by the husband, were to be treated as the husband's own properties. Now, on a straightforward application of the rule in Salomon and Salomon, the answer would surely be no. The company's properties are not the husband's properties. But the Supreme Court held to the contrary. The Supreme Court held that the true analysis was that the companies held the properties on trust for the husband. The husband was the true beneficial owner, and therefore the properties were his property and had to be brought into account in the divorce settlement. So you might think that that provides a really good example of piercing the corporate veil. No, not at all. The Supreme Court said that it was not piercing the corporate veil. How so? How do you get to the result that the company's assets belong to the husband without piercing the corporate veil? Well, Lord Sumption drew a distinction between two separate principles as he saw it. One, the concealment principle, and two, the evasion principle. In Prest, Lord Sumption said that he was dealing with a case of the concealment principle. The concealment principle applies where a corporate structure is used as a facade to conceal the identity of the real actors, such as the true beneficial owner of assets or property. And what Lord Sumption said was that the court doesn't disregard the facade entirely, doesn't pierce the veil. The court merely looks behind or beyond the facade of the corporate veil to discover the true facts. And he said that this isn't an exception to the rule in Salomon at all on a proper analysis. In fact, he said, it's legally banal. It's not a case of saying that the company's assets are the husband's assets. It was saying that beneficially, the assets were not the company's, had never been the company's, and in truth, they were always the husband's assets. There are other legally banal examples which fall within the concealment principle or very closely related concepts. So, for example, an individual may be liable on a company's contract if, on a true analysis, the company entered the contract as an individual's agent, and the individual is as liable as an undisclosed principal. But again, that's not piercing the veil. That's merely the application of a very well-established legal principle, that of agent and undisclosed principle. True piercing of the corporate veil, according to Lord Sumption, is limited to the evasion principle. And the evasion principle arises where a person is under an existing legal obligation or liability, or subject to an existing legal restriction, which he deliberately evades, or whose enforcement he deliberately frustrates by interposing a company under his control. There are two further restrictions on the evasion principle. First, the court may pierce the corporate veil only for the purpose of depriving the company or its controller of the advantage that it would obtain by abuse of the company's separate legal personality. And, second restriction, the court will only pierce the corporate veil if no other route to appropriate relief is available. In other words, if the application of more orthodox principles achieves the right result, such as the application of the concealment principle or the law of agent and undisclosed principle, there will be no piercing of the corporate veil. And that's why the Supreme Court, in Prest, said that that case itself was not a case of piercing the veil because there was another route to achieve the right result. And what Lord Sumption said was that that meant that many of the previous cases needed to be reanalyzed. Although judges in previous cases thought, and indeed said expressly, that they were piercing the corporate veil, Lord Sumption, in his infinite wisdom, tells them retrospectively that they weren't. They were wrong. They were, properly analysed, applying a much more banal approach, such as simply identifying true beneficial ownership. This, I think, though, gives rise to perhaps something of an irony when we ask what the effect of Prest is going to be. Certainly, I think we can say that the ability of courts to defeat concealment or fraud is undimmed and probably enhanced. And it might be said that the unyielding rock of Salomon may be found to yield rather more easily in the future. And that is what we now mean by piercing the corporate veil.